Great. Well, thank you and welcome to this new season of i3 webinars. It is lovely to be back. Today's topic is surrogacy. So with surrogacy regulation shifting in so many countries, it is more important than ever for clinics to understand the legal and ethical considerations around national and international surrogacy. Our panelists today will highlight key developments impacting surrogacy, including recent changes to surrogacy laws in the UK, cross-border reproductive care in Europe. They will offer strategic advice for navigating different national laws. We'll touch on surrogacy in the US and state-by-state differences. And finally, best practices, which are arising in India and around the world. So I am joined by my co-hosts, highly experienced UK lawyer, James Lawford Davies. James is a partner at Lawford Davies and Company, a law firm with offices in the UK and Germany. James specializes in life sciences regulation and litigation. Dr. Keshav Malhotra is a clinical embryologist, the lab director of Rainbow IVF, and now the director of Malhotra Embryology Training Academy, and is heavily involved in the International Society policies. We also have Dr. Mara Simopoulou, who is an associate professor of physiology and embryology at the medical school at the University of Athens, deputy laboratory manager, and now elected as a member of the ESHRA Committee of National Representatives representing Greece. Welcome.
Thank you for the intro, Dr. Jindal. To introduce you, Dr. Jindal directs IVF labs in the US and also serves on the ASRM Practice Committee. She was the co-president of the Society of Reproductive Biologists and Technologists, SRBT, in 2011, and is currently the president for the Society of Assisted Reproductive Technologies, or SART. We will keep the bio short because we want to get as much out of the webinar as we can, because that's what we are all here for. You know that you can find all of these webinars on i3 or ivfmeeting.com. Please remember that the certificates are posted in a few days and not immediately. So you will get your certificates and hopefully by the weekend. Tonight, we ask you to place all your questions in the Q&A section and not in the chat section. And definitely please take part in all of the discussions. Over to you, James.
Thank you very much, Keshav. And it's really good to see so many people here this evening, this morning, this afternoon, depending on where you are. So as Sangita mentioned, I am a lawyer working in IVF and embryo research based in the UK. And unlike Ellen, who's going to speak later, who specializes in advising patients, almost all of my work is on behalf of doctors and embryologists and researchers and clinics. And I've always found surrogacy a fascinating area as a lawyer. It brings together in a unique way a truly unusual combination of legal issues, questions, and problems, bringing together the rights and interests of a wide variety of different individuals and stakeholders. So we have obviously the couple, the commissioning couple, or the individual who are seeking surrogacy. We have any donors that they may decide to use as part of their treatment. We obviously have the surrogate mother herself, and then any child or children that may be born as a result of the treatment. But the process also brings into play the interests of the clinics and the staff that provide treatment to these individuals and surrogates. And those staff are increasingly expected to at least have a knowledge, if not a proper understanding, of the legal and regulatory implications of providing surrogacy, whether in their home country or referring patients for treatment abroad. And surrogacy may involve companies or charities or other organizations who help facilitate surrogacy arrangements, whether altruistically or commercially. And I'll come back to that in a moment. So there's a wide variety of different interests at play in surrogacy, and they don't always align, particularly where there are misunderstandings or misconceptions or, heaven forbid, where mistakes happen. Now, this mix of interests and sometimes conflict of interests is more manageable when the treatment is all happening within one jurisdiction. But in the context of international surrogacy, we introduce a further tier of complexity due to the variety of legal and regulatory requirements that can apply around the world. International surrogacy is part of a growing phenomenon of people traveling to access different forms of assisted reproduction in other jurisdictions, which is sometimes referred to as cross-border reproductive care. There's still relatively limited data available about how many patients travel abroad for surrogacy, where they go, and what their motivations are. Although there are a good number of papers that are emerging now that have sought to analyze this. And there's a particularly interesting series from some friends and colleagues of mine in Cambridge with a London law firm that have looked at precisely this question. But it is still early days in understanding who goes where for what and for what reasons. And there are obviously a number of advantages in seeking surrogacy treatment abroad, which may be the basis and the reason why people seek treatment outside their country of origin. Perhaps the most obvious is finding treatment more cheaply, more affordably than it's available at home. It may be that they're seeking better availability and accessibility of surrogacy. It may be that they are looking at countries that have little or no regulation because of restrictions that they have in their home country. It may be that they're seeking a wider diversity or range of potential surrogate mothers than they can find at home. And it may simply be that they can find treatment more quickly than joining a waiting list and having to wait a long time in their country of origin. But there are also potential disadvantages and complexities. The most important that I will keep coming back to is that the vital element of there being very different legal and regulatory requirements in different jurisdictions, which patients have unfortunately often failed to appreciate and sometimes grossly misunderstood and underestimated in terms of the implications that that can have for them when they try to go home. There can be potentially significant complications, and there have been a number of high-profile cases in the news in recent years, particularly in relation to embryo mix-ups, which have led to legal disputes, litigation, and incredibly distressing circumstances for certain families who've sought surrogacy treatment abroad. There can be questions relating to citizenship, and there is a risk of children ending up stateless, as we've also seen in a number of recent cases. Some patients have complained about encountering hidden costs when they've sought treatment abroad, and there are obvious travel requirements and complexities, and that again has been in the media recently due to the war in Ukraine and the consequence that that has had for patients who've been seeking treatment there. But one of the key reasons for the complexity in relation to international surrogacy is that these legal and policy responses to surrogacy differ notably and widely between different countries. So in some countries, as I know we'll come on to see in a moment with one of the talks, surrogacy is forbidden, it's prohibited by law. A good example of that is Italy, where it's already forbidden in Italy, but the Italian government have recently introduced or approved a bill which would criminalize patients seeking surrogacy overseas. There's also significant variation in whether surrogacy agreements can be legally enforced, and the process of assigning legal parenthood in those jurisdictions where surrogacy is permitted. And in some jurisdictions, we see that the intended parents are granted legal parenthood at birth, whereas in other jurisdictions, legal parenthood is initially assigned to the surrogate mother and then must be transferred to the commissioning parents, which often requires the intervention or the need for a court application. And there may be restrictions on who can be granted legal parenthood at all in terms of patient demographics, such as marital status and sexual orientation. Another notable distinction and dichotomy, which I know we're going to look at this evening, is that surrogacy is commonly split between commercial surrogacy and altruistic models. Commercial surrogacy typically is an arrangement which is facilitated through a commercial market with brokers, agents, lawyers, or clinics involved, and that provides services to intended parents where the surrogates are paid and receive financial benefits for providing surrogacy services. And conversely, in altruistic surrogacy, the surrogate generally only receives compensation for surrogacy-related expenses that they incur. And any intermediaries that facilitate those arrangements operate on a non-profit basis. And that's the approach that's been adopted to date in the UK. But the distinction between those two models is in itself controversial, because on the one hand, what constitutes compensation in an altruistic arrangement has been very widely interpreted, even in the UK. And on the other hand, payment doesn't necessarily negate an altruistic motivation on the part of the surrogate. But we can debate that later if that's of interest to you. That distinction has, however, shaped the way in which law and policy in response to surrogacy has developed in all sorts of jurisdictions. And although some jurisdictions allow commercial arrangements, others only permit altruistic surrogacy as a matter of law. And this diversity in regulatory approaches has led intended parents to travel to access arrangements in jurisdictions where legislation may be more permissive and allow them to do something that they wouldn't be allowed to do at home. But that still requires that they understand local law and regulation. And I find myself regularly, weekly, advising clinics to make sure that if patients are seeking treatment abroad, that they get advice on what that local law may mean for them and for any children born as a result of their treatment. There is no international framework for the regulation of the quality and safety of international surrogacy, nor is it ever going to be likely or feasible to introduce such a regulatory framework. That lack of regulation and cooperation in the context of international surrogacy can create problems. It can create or leave children stateless and without the protection of citizenship. It can cause significant difficulties for parents and surrogates, and it can create difficulties for clinics as well. So that, I think, means that this is a very welcome discussion so that we can better understand how to navigate the international surrogacy and ensure a safe, smooth treatment pathway for all concerned. And on that note, I will hand back to Keshav.
Thank you for that brilliant introduction to surrogacy, James. I have a few questions for you, and maybe then we can move on to the next speaker. I think the first one that I would like to discuss is, when does the expenses stop and when does payment begin? A surrogate mother may need money to cover like prenatal care, experience loss of work, etc. So, I mean, how is that structured?
Yeah, it's a very good question, and it's been a little controversial in the UK because, as far as I'm aware, and there are others on the call who I'm sure will shout if I'm wrong about this, I'm not aware that any expenses have ever in fact been rejected in the UK. And some have been significant. There are expenses that have been incurred which might raise an eyebrow, but they've always been approved. And you're quite right, there's a very grey area between what constitutes an incentive and what constitutes a reasonable compensation. But that's why I make the point that it isn't a clear binary distinction. It is quite a grey area.
And that's where we struggle with, let's say, commercial and altruistic surrogacy, because if there are certain incentives which are being, let's say, misused, it might have a commercial angle to it. And we have knee-jerk reactions from governments based on these incentives. And that's why I think we're all like now discussing this at I3. I think we'll come back to you with more questions at the end of the session. I would also request all participants to please put in their questions in the Q&A section. We'll move on to our next speaker. Our next speaker is Pedro Brandao. He's a gynecologist at GyneMed Porto, dedicated to assisted reproduction with a special interest on reproduction for minorities, in particular the LGBTQIA plus third-party reproduction and also international affairs. Pedro, the stage is all yours.
Good evening. And thank you for the introduction, and also thank you for the invitation for participating in this interesting initiative, the I3, and actually specifically for this interesting subject as well. I'm just moving to my presentation. So this presentation will be like an overview of commercial surrogacy or surrogacy in general. Some of the topics we have already discussed it here, and specifically James has already introduced some of the topics that we are going to talk about. Actually, and again, as we were speaking just a few seconds ago, it's really, really difficult to define what is altruistic surrogacy or commercial surrogacy. What is a payment, or what is a compensation, a reward, or what is just paying for the expenses of the surrogates, and what are medical expenses or expenses related to pregnancy itself or not. So this is a very big gray area to distinguish these two entities. But in general, we know that there are 2 points to what is the pure altruistic surrogacy, which is that you cannot compensate, not even for the expenses, and what is the pure commercial surrogacy, which means that you can pay for the surrogates and she has to pay taxes for that. That would be a payment. So for the last few years or decades, the industry of surrogacy, it has grown a lot. As you can see, in the early 20s in Thailand and India, it worth like millions of dollars, and in 2012 it was estimated to worth around $6 billion in the United States, and it has increased a lot. Some agencies report as 6,000% growth in 12 years. So this is amazing. These numbers are, they really reflect how this market is evolving. Some of the people, they say, we must not accept commercial surrogacy or compensated surrogacy. And why not? There are a lot of arguments against the commercial surrogacy. One of them would be that these women, the carriers, they could be regarded as a way of conception. And this could be also by the point of view of the baby, this could be a way of marketing babies, of selling babies. Also, there is some concerns about the risk of illegal exploitation of these women, of course, and we know that unfortunately it has happened before in history, and it keeps on happening nowadays. And interestingly, there are some people that defend that this can be regarded as a different way of prostitution or donating or selling organs. So this could be regarded as a way of using our own body for non-socially accepted purposes. But there are of course some different opinions. Why we must accept commercial surrogacy. Some say that this is no worse than poorly paid dangerous jobs. I mean, if you work like in fishermen in a dangerous sea, and you have to face challenges, and you risk your own life and you get badly paid, this could be no worse than that. People and the defenders of the commercial surrogacy, they defend that the carriers, it's their free will, so they have the power to decide if they want to do that or not. And also, it's important to note that if you are going to compensate this carrier, she will have some kind of reward for her efforts. So it would be a win-win relationship. I mean, if we look at these poles, no compensation or compensation, one may think that not to compensate would be good because this is purely altruistic. But if we think about it, these women will suffer some damages to her body, and eventually she will face some risks during pregnancy or after pregnancy, and she is not going to be rewarded for that. Instead, if we are opting for a compensated surrogacy, this will be a win-win relationship. All the parties involved will be rewarded or will have some kind of compensation for that. But some say that this could be some kind of commercialization or marketing the process. So if we think about it, both if women are not compensated or if women are going to be paid for that, they could be regarded as a way of exploitation. What are the motivations for women to go to surrogacy? This has already had a lot, there are a lot of publications about the subject. Altruism is one of the main motivations for sure, but there are also a lot of women that have a strong desire for a different kind of motherhood. And interestingly, there are a lot of women that wish to be pregnant again, but they cannot afford, or they just don't want to have any more children or any children at all. There are some studies that also report some cultural beliefs behind the surrogacy, but this is not so relevant. In general, if we are speaking about commercial surrogacy, the most important motivation would be monetary compensation. There are, and James has already spoken about that, a lot of agencies and companies dedicated to mediate surrogate treatments. Some of them are local agencies operating only in that specific country, and some other agencies, they operate worldwide. So couples wishing to do a treatment abroad, international surrogacy or reproductive tourism, as we may call that, or cross-border reproductive treatments, they can go to these or contact these agencies, and they will mediate all the process, the matching of the intended parents to the carrier, medical coordination, counseling of both the intended parents and the carriers, and also some supports in terms of administrative processes, legal support, and also the financial management, of course. There are some concerns about these agencies. Most of them, they have two kinds of plans. They have basic and guarantee plans. And with the guarantee plans, usually they guarantee a live birth. But these agencies, and some of these topics Jim has already pointed out, that some of these agencies, they take for granted that the surrogates have no legal maternal rights. And this is not always true, depending on the country or the state. And also, they state that in case of litigation, law always protects the intended parents. And another important point about these agencies is that they give legal support in the country that the process of surrogacy is happening, but they do not give legal support in home country when intended parents come back home with their babies. But overall, these agencies, they are important means to reach the surrogate contracts and to help to mediate all the processes between the intended parents and the surrogates, or the carriers. If we look at the costs, and we are speaking about a specific case of commercial surrogacy in the United States, it's the most expensive one, but it's also the one with the more regulated one. And we can estimate, as you can see, a total of $100,000 to $200,000 per surrogate process. So it's quite expensive if we look at the gold standard example of surrogacy. Of course, there are a lot of countries that offer this possibility, either commercial surrogacy or altruistic surrogacy. Here you have a list of the countries, the most commonly named countries for surrogacy. And as you can see, the United States is much more expensive to do that in the US compared to other countries. But there are some countries like the UK, for instance, or Canada that you can estimate around 100,000 euros. And this is because most, as we can come back, if we look at the carrier compensation, this is not the largest part of the costs of this process. Then you have the South American countries, and usually the most used countries are Mexico and Colombia, which are less expensive. And then here in Europe, we have Ukraine and Georgia, which are the ones that people most commonly go to for surrogacy. This is a map of countries worldwide in which we were able to retrieve some information about surrogacy. And as you can see in Europe, most of the countries, they ban surrogacy and all kinds of surrogacy, especially Western Europe. And the remaining countries in Western Europe, we speak about altruistic surrogacy only. In the United States, it depends a lot on the country. There are some states, and we have a special session dedicated to the US, some states that do ban all kinds of surrogacy, and some states that you have the possibility of doing any kind of surrogacy. In Canada, only Quebec bans surrogacy. All the other states or the other parts of the territory, you can resort to altruistic surrogacy. As you can see, most of the countries, especially in South America, you have no regulation, regulating, sorry for the misspelling. You have no regulation on surrogacy. So this means that you can do, it's not illegal, but it's not legal. So in case of litigation, you don't have a specific law protecting you. This is another summary of the most important, I mean, the countries that are most commonly used for surrogacy. And as you can see as well, the only country that you have commercial surrogacy and everything is green, I mean, all kinds of patients, being heterosexual couples, male couples, female couples, single women, single men, can resort to surrogacy. The only country that you can do it commercially and international patients have the possibility to go there is the United States. Most of the other countries, either you have to resort to altruistic surrogacy, and then you have the problem of the lack of availability of carriers, or you cannot go if you are international patients, or you can only do that if you are within a heterosexual couple. For the last few years, there have been some limitations to transnational surrogacy. For instance, in my country, in Portugal, surrogacy was approved by law in 2021 exclusively for nationals or residents, and it's still not in force. So we're not doing surrogacy in Portugal yet, but we are waiting for surrogacy to be regulated. It's already legal, but not in force right now. During the last decade, Southeast Asia, Asian countries like Cambodia and India, they banned surrogacy for international patients. And there has been an important case, which is called the Baby Gamis case in Thailand in 2013, in which an Australian couple resorted to surrogacy in Thailand, and they had a twin pregnancy of a boy and a girl, but the boy has Down syndrome, and the carrier did not accept interruption. So the couple brought back home only the girl and left the boy in Thailand with the carrier. And this was a very mediatic case, of course, and this led Thailand to think about their international policies on surrogacy. Some other states and countries, like Tabasco, for instance, in Mexico, or like Georgia, they are taking measures. Tabasco has already taken, but Georgia, for the last couple of months, the government is trying to take measures to limit or control transnational surrogacy. Right now, what is the current situation? Heterosexual couples in general, if they want commercial surrogacy, of course, the best country to resort with regulated things and things to go to avoid litigation, any kind of problems, would be the United States. The problem is that surrogacy, as we have already seen, it's quite expensive. Most couples that cannot afford to go to the United States usually go to Mexico, Colombia, Georgia, or Ukraine. Nowadays, Ukraine has the problem of the law, of course. Georgia is still a possibility, even though the government is trying to limit foreign patients. And Colombia and Mexico, things are working well until now, but there is no specific legislation about surrogacy. So what happens is that most of the cases have been under court decisions, and things have been running well until now. So in case of litigation, or if there is any problem, there is no guarantee that things are going to be as well as they have been until now. If we are speaking about altruistic surrogacy, then we would have a lot of countries as well with things very well regulated, but there is a lack of carriers available to go on this process. So patients may eventually expect 2 or 3 years of waiting list or even more. If we speak about same-sex couples, Eastern Europe is not open to same-sex couples to resort to surrogacy. So most of the couples, they have to resort either to the United States if they can afford these kind of treatments, or South America. Thank you very much for your attention. Obrigado.
Thank you very much indeed, Pedro. That was a brilliant overview, and I certainly learned a lot. Can I ask one quick question? I touched at the end of my talk or introduction, I gave a slightly bleak prediction that it would be impossible to introduce international regulation. And there are lots of reasons why I think it would be difficult. Do you have any thoughts or ideas about how we could police surrogacy at an international level? I mean, I know from past experience with stem cell research, there were discussions about how that could be regulated internationally, and it was just agreed that we would try to introduce professional standards and research standards that would become universally acceptable, and anyone that fell short of that would be rejected, and we could tell patients to avoid them. Do you have any thoughts about how that might work in surrogacy?
It would be really, really difficult, as we know. Unfortunately, there are some entities that tried to do at least some kind of guidelines to mediate this, or not specifically legislation, of course, but some sort of guidelines to try to get things uniform around the world, or worldwide, or at least specifically regionally, for instance, in the European Union, for instance. But even if we think about the European Union case or the United States, which is a country itself, we have a lot of different legislations around between different states and between different countries in the EU. So it's quite hard to get things uniform. For instance, you gave the example of Italy. Italy had already some problems with patients coming back home with their babies, and it happened already in France. And the European Court for the Human Rights, they have decided, in case of the French case, to give the nationality, or not mandatory thing, but to counsel, to recommend France to accept the nationality of that baby and to recognize parenthood of those parents, thinking of the best interest of the baby. Nowadays, we are seeing the example of Italy that's doing the exact opposite of this. So it's quite hard. It depends. It has a lot of political implications as well, as we know, since the Italian government now is a far-right government, and they are completely against any kind of LGBT reproductive treatments. So it will be really hard to have things uniform around the world.
Thank you. Well, hopefully you'll be able to answer some more questions at the end of the talks.
Thank you very much.
Our next speaker has been working in this field since 1998. Sanjay Shukla is a senior consultant clinical embryologist and adjunct professor of clinical embryology at the Department of Reproductive Medicine and Surgery at the Mahatma Gandhi University of Medical Sciences and Technology in Jaipur, India. Unfortunately, Professor Shukla isn't able to join us live this evening, but he has a recorded presentation, which I'm hoping will appear now.
Hi, this is Sanjay Shukla from Jaipur, India. I'm basically a clinical embryologist working in the field since '98. And I'm also a visiting professor of clinical embryology and reproductive medicine in the Mahatma Gandhi Medical College, Jaipur. So I'm asked to speak a little on the surrogacy scenario in India. And I hope many of you might be knowing the current status of surrogacy in India and what was it like in the past. So to start with, it was the surrogacy as such was practiced in India ever since we started IVF in India or ART services in India, but the commercial surrogacy in particular was legalized in 2002, and it remained so until November 4, 2015. And over these years, it became a very lucrative business in India because of the great global demand and the medical infrastructure that was available in India. Then it was largely not just the surrogacy, but entire ART sector was largely unregulated. And there was a guideline proposed by the Indian Council of Medical Research in 2005. And it also included partly the surrogacy. And it said that the surrogate mother would be entitled to monetary compensation. And the value of this compensation could be decided by a mutual agreement between the intended couple and the surrogate mother. Also, that the surrogate mother cannot donate her own eggs for the surrogacy. But otherwise, the sector remained largely unregulated. This is a clip from a newspaper, and it tells you about the pre-surrogacy, commercial surrogacy ban era in India. At that time, it was believed that this business is booming like anything, and the commercial surrogacy industry was estimated to be in the magnitude of almost $2.3 billion per annum. And by that time, nearly 25,000 children were born, of which almost 50% of them were from the West. So what was it that people were coming to India for this particular surrogacy business? One, because the medical facilities were cheaper in India. Advanced technologies like all ARTs were available in India. We had good doctors, and more so the language, because most of us do speak English language, and it was easier to communicate for the Western couples with the doctors and most probably with the intended surrogate mothers. Then another thing which was a basis of this boom was the availability of surrogate mothers, because poor socioeconomic conditions and the poverty or the need of the couples made them that the women opted for to be surrogate mothers. So these were some of the major players, and then the lack of regulation which I already mentioned in my previous slides. So these were the things which made India a center, a hub for the commercial surrogacy before 2015. Then in 2015, and this happened because of certain incidences that were not very pleasant incidences, or the some, you can say, side effects of the commercial surrogacy, which was unregulated, that the Indian government put a sudden ban on the commercial surrogacy and prohibiting surrogacy for the foreign nationals. Then this led to the formulation of Surrogacy Regulation Bill 2016, and it was introduced in the Lok Sabha, that is the lower house of the parliament. But the parliament was adjourned sine die, and it did not realize in formation of a bill or act. This is a slide from, and this data is taken from a very popular surrogacy clinic from Gujarat. And probably at that time, it was the largest surrogacy clinic in India. And you can see the growth of surrogacy from 2015 to 16 until the surrogacy ban was imposed for the foreign nationals, and then a sudden decline of the surrogacy cases at that particular center. This was a representation of what happened to other centers also across the country. Then this 2016 bill was again sent for the standing committee, and formulated again in 2019. It was again tabled in the parliament. Then this was sent to the upper house, and where another standing committee reviewed the bill. And then in 2020, it was again tabled, and it saw in 2021, December 25, that the bill was finally passed by the parliament, and it was implemented since January 2022. So this formal bill states, besides many other things, that the intended parent should not have a biological child, an adopted child, or another child through surrogacy. And this could be availed by a couple wherein the woman is between 23 and 50 years, and the man is between 26 and 55 years. Women between the ages of 25 and 35 are made eligible to be surrogates. This bill also allows widows or divorcees who are between the age of 35 and 45 years to avail these surrogacy services through ART. Then eventually there were two amendments which made insurance cover of the surrogate mother mandatory for a period of 36 months. That includes the postpartum health coverage also, to safeguard the needs of intended surrogate mother. And also the NRIs, or the couples of Indian origins, are made allowed to avail these services. But herein they clarified that both the partners of the OCI couples, that is the non-resident Indian couples, must be Indian origin. This bill also states about the punishment, because this is a punishable act, that the evading the law the punishment is 10 years imprisonment and rupees 10 lakhs fine for the clinics and 5 years in jail and a rupees 5 lakhs fine for the intended parents. Eventually, because the bill states that there are certain steps and in implementing these rules and regulations, so they have formed a portal wherein all the clinics need to be registered before they offer the any ART services, including the surrogacy. So this was taken, this picture is from the portal, the Indian National ART and Surrogacy portal. And if you see, only 911 clinics have formally applied for the surrogacy services, and only 132 surrogacy clinics have been given license to practice surrogacy, along with other ART clinics. So this is the current scenario, and this means that probably because most of the business is coming, was coming from the foreign nationals. So particularly Western countries, the surrogacy has come to a halt practically. Also, only altruistic surrogacy is allowed. Now the altruistic surrogacy, and again, the law says that only the close relative can be a surrogate mother. So not any woman can become a surrogate, but only a close relative can be a surrogate mother, which was in previous version of the bill, which was proposed in 2016. This clause was not there, but now they have gone back and they have made it compulsory that only the close relative can be a surrogate mother. So there are certain hurdles, and they have also excluded gay people, single men, and I mean, they have allowed the divorcee and single women, especially those who are widowers or the divorcee, but they have excluded the especially LGBTQ and single man from availing the surrogacy. So what we have seen over the years that the surrogacy in India has become a very difficult part of ART services, and only a few clinics are now offering this. A lot of things are on stake, and probably many NGOs and social groups are involved in this thing. So there are another group of NGOs who are advocating surrogacy and some relaxation in the laws. So maybe we can expect some amendments in the coming times, and hopefully the surrogacy in India can again achieve, if not the pre 2015 era, but maybe up to certain extent that we can have sufficient number of patients who can avail the surrogacy through ART. Thank you. I would also like to clarify that the ART services are now properly regulated in India post the introduction of this 2021 ART laws, the ART Act 2021 and Surrogacy Act 2021. And most of the ART clinics now practicing in confidence with the guidelines and the regulations that are imposed by the government, and they are abiding by the laws. So the misconception that the some of the countries might be having on India as it was earlier. It is no more so, and most of the clinics are working ethically and in lines with the newly led government regulations.
Oh, that was amazing. Dr. Shukla, Sanjay Shukla, thank you for that amazing video. I'm sorry you're not here to answer questions, but Keshav, I wonder if you'd be willing to take a question on just the general state of surrogacy in India. And I just want to clarify, so the new law has come in, and so the good news is that these sentinel events are not happening the way they used to, but my impression from the talk was that the volume has dropped. Is that
Yeah,
correct?
absolutely.
Yeah.
Absolutely. Like, as far as I know, in the last 2 years, I don't think any case of surrogacy has happened in the country. It's become very difficult for patients to get approvals. Um, the problem that we're facing is that the criteria is so restrictive that it actually, and the legal process is it's so intensive that most patients who are even like trying for surrogacy are now looking for options outside of India, and that's something that all of us reproductive medicine specialists are actually now trying to address with the government, and hopefully we can only hope that these regulations might get amended a little bit for the better. But I mean, the benefit of these amendments have been that the exploitation that was being highlighted within the global community, all of that has stopped. It was a knee-jerk reaction, but uh, in the near future, hopefully, we'll have more inclusive policies for everyone, and hopefully the process would become easier for patients.
Yes, I hope so. And as someone alluded to earlier, the politics and the ruling parties, particularly, I think the reference was in Europe, this often dictates the way these services are offered, reproductive services. So we will hope for the best in India. We'd like to see that the usage is improved and that there's access to care for couples and single people and LGBT, everybody who requires surrogacy. We're hoping that will happen. Thank you for answering that question. And thank you again, Dr. Shukla. And it's my pleasure to invite the next speaker. I think the last speaker is Ellen Trachman. So Ellen Trachman founded Trachman Law Center, LLC, in order to bring dedicated and compassionate legal representation to those wishing to build a family through ART. Ellen was an undergrad at UC Berkeley, University of California in Berkeley, and at school in Emory, which is in Atlanta. And she writes a regular column on ART legal issues for Above the Law and co-hosts the podcast, I Want to Put a Baby in You. I love that. Ellen was honored to be named Ally of the Year in 2020 by the Colorado LGBT Bar Association. Ellen, we're looking forward to your talk. Thank you.
Thank you for that introduction. As one does, I'd like to explain my picture on the front of my slide. So I'm an assisted reproductive technology law attorney, which we abbreviate as ART law, which can be confused with paintings and statues. So because of that confusion, I have this lovely picture of the Mona Lisa with her clearly IVF conceived baby. And you know it's a good joke because I had to explain it, right? Okay, on to the presentation. Okay, a few disclaimers. As an attorney, I love to give disclaimers. No attorney-client relationship formed by attending this presentation. So normally, if you tell me you murdered someone, I keep that information private. If you put in the chat here, I will have to report you. I am licensed in California, Colorado, New Mexico, and Montana. So those are the 4 states I can speak on with great knowledge and being licensed there. I will speak generally about other states, but those are my 4 licensed states. And then I have a law partner who's licensed in New York and New Jersey. And then I will note that I'm a co-owner of what we call an agency, so Bright Futures Families, which does surrogacy, matching, and support in the United States. Thank you for that great introduction. So I'll skip all of this except for to show you my 4 adorable children, myself, and of course, my adorable puppy Teddy that I put throughout the presentation in case the content isn't good. You can enjoy the joy of seeing an adorable puppy. Okay, so there's a visualization of the states that I practice in. Colorado in the middle is where I reside in Denver, Colorado. A little roadmap. We'll talk about the nature of U.S. surrogacy, the 50 different legal systems. We'll just go one by one. Just kidding. I'll give some examples. Cost overview, which great presentation before on costs. That was great. Insurance, citizenship and travel issues, and some recent legal changes that affect surrogacy overall. Okay. First, the nature of U.S. surrogacy. While surrogacy compensation is generally supported, I will note that what we find for those of us working daily with surrogates, it's not the main motivation, or at least it's never expressed the main motivation. In fact, for those applicants that say their main motivation is compensation, they probably wouldn't qualify as a surrogate. Of the applicants that apply to be surrogates, which already whittles down, who would like to carry a pregnancy for someone else, it is actually very hard to qualify as a gestational carrier in the United States. From our own matching and what we've seen across through other surrogacy agencies, is generally around 5 or 6% of those who've already volunteered to be a surrogate actually qualify to go forward. That's because they have to have essentially perfect pregnancies previously. They must be between a certain age. They must have a certain BMI that's healthy. They have to be financially stable, etc. So we generally see that surrogates choose to become surrogates because they are parents themselves and they understand how important that is to so many people. Often they've seen friends or family who've experienced fertility issues and they really want to help someone else become a parent. The other big nature of U.S. surrogacy that I think is very different than other countries is it's really relationship based, that we see our surrogates choose to become surrogates to help others become parents. But they also expect to know the intended parents. They expect them to be there and to see this beautiful moment of holding their baby for the first time. We expect communication during the surrogacy, involvement of the intended parents, checking on how the appointments are going. Obviously, I only practice in the United States, but in our few instances, so the podcast, for example, we had a friend of mine actually, who went to surrogacy in Mexico. And I was shocked to hear that she was not permitted to have any contact with her surrogate. She was told that otherwise the surrogate might exploit her, ask her for additional amounts of compensation, which is not what we see as a practice in the United States at all, that there is agreements put in place beforehand in terms of compensation, reimbursement. Everything's agreed before she becomes pregnant. Money is held by a third-party escrow agent, so it's not even the intended parents that are paying directly at that point. It comes from the escrow agent. So we don't see that kind of lack of contact. Generally, it's a healthy communication, and the surrogates want to be, seen and appreciated throughout the journey. Okay. There is no one set of laws throughout the United States. There's 50 different set of laws. Every state addresses surrogacy in its own way. There are certain states that do not permit it or have certain restrictions. Michigan is probably the most notorious, where surrogacy, or at least compensated surrogacy, is criminalized. But even cases of altruistic surrogacy in Michigan, we've seen it's very hard for intended parents to be recognized as legal parents. But most of the country is very surrogacy friendly, and we see lots of intended parents, both domestically and internationally, coming to work with surrogates in those states. So there's a general map. So most of it, as you see, is green, some red states, but I will note that even this is extremely simplified. I noted Michigan's especially bad, but Arizona is red here, but I know Arizona has a law that says a surrogacy contract will not be honored, but lots of surrogacy happens in Arizona, where we see the contract itself might be done in a different state that has jurisdiction, and then Arizona attorneys are able to secure parentage for intended parents in that state. So even if something is completely red, there's always degrees of whether surrogacy is really happening or whether it can happen in that state. And same with the green states. So even though we've kind of equally put everything green, there's a lot of variation about what that green might mean. So I will give an example of one state. So, of course, I chose my home state of Colorado. Colorado passed a surrogacy-specific and supportive law in 2021. Prior to 2021, there was plenty of surrogacy happening, lots of intended parents coming from abroad as well as domestically to work with surrogates in Colorado, and the judges in Colorado were happy to grant parentage orders. However, Colorado chose to codify best practices and put into the law its Colorado Surrogacy Agreement Law. The law provides that intended parents do not have to be married. They do not have to be different sex. They can be same-sex couples, and they don't have to be genetically related to the embryo. And I would say that one is distinguishable from a number of states which would require a genetic connection at some time. There are certain requirements that the law requires in the gestational care agreement. So, for example, both parties must be represented by Colorado legal counsel. So, the gestational carrier has a lawyer representing her best interests. The contract must provide that either party can terminate the agreement at any time the surrogate's not pregnant. So, for example, even though intended parents might pay for her to go through screening, pay for her attorney, pay for various expenses before she goes through an embryo transfer, the day before or the day of, if she says, I've changed my mind, I don't want to do this, she cannot be penalized for backing out. And I will say part of that, the reasoning behind that is we don't ever want surrogacy to be coercive, that she might have to pay back expenses or be penalized for choosing not to go forward. Another unique element of Colorado surrogacy law is Colorado surrogacy law treats genetic or traditional surrogacy identically to gestational surrogacy. So in that case, the surrogate probably did not have an embryo transfer, but an IUI, and the child is genetically related to her. So essentially, she's considered an egg donor and a surrogate at the same time. Despite that similar treatment, I would say that genetic surrogacy is still incredibly rare. And part of the reason is that most states are not so supportive of genetic surrogacy, where, especially if there might be compensation involved, it could cross lines where there can't be payment. It could look like a paid adoption, which would be illegal. Other states might allow just genetic surrogacy, but allow the surrogate to change her mind or have rights of changing her mind at some point. So Colorado is definitely unique in that element. Thank you for the previous discussion of expenses. I feel like I can skip a lot of this. The general message is that surrogacy is very expensive in the United States. I saw the number, the 150 to 200, I think is a fair number. Part of the reason, so it goes into different parts, but embryo creation, if there is a donor needed for the embryo, that also increases the cost. The matching agency, if you need help finding a surrogate, and then, of course, the compensation of the surrogate is a big element. I would say the average right now is probably $45,000, $50,000 for a base compensation for a surrogate in most states. And that's plus that you're paying additional expenses, such as when she starts medication, you're generally paying a life insurance policy for her, maternity clothes, etc. The next big element that I will go into a little bit more detail is insurance and medical costs. So this becomes an incredibly expensive element of surrogacy. So I'm sure of the breakdown, this is a big chunk of it. So in one part, there's the IVF process, the embryo creation. And even for US citizens, this is generally often out of pocket, where our insurance does not cover it. There has been movement to have laws passed in various states to have insurance cover fertility treatment, and we've seen some progress, but it's still not in a majority of the states. The next part is the insurance for the surrogate herself, for her medical care during the pregnancy. Sometimes a surrogate has an insurance policy that's surrogacy friendly. Other times, her policy might exclude coverage if she's acting as a surrogate. The other complication is sometimes her policy might say, yes, we provide coverage when she's a surrogate, but we might put a lien on her compensation. So, for example, a 50% lien on $50,000 in compensation would say you intended parents need to pay back $25,000, the first $25,000 in medical expenses. So the liens can make that insurance policy maybe not a good fit. So in those cases where she doesn't have a policy, has a lien or there's some risk in the policy, often intended parents have to buy a separate insurance policy for the surrogate. The next insurance part, so many insurance parts, is for your newborn child. So if you were a US citizen, your child would naturally go onto your insurance. But for international intended parents, they often have to buy a separate insurance policy for their newborn's healthcare. And if there's complications at birth, it becomes especially important to have that insurance. Okay, briefly, citizenship and travel. So most states have a process that will recognize intended parents to be the legal parents upon birth. So the 4 states I practice in all recognize that the intended parents are their parents of the child before the child is born. So that only becomes effective upon birth, but that legal process happens during the pregnancy. And then the second the baby is born, intended parents are the legal parents. Their names go directly on the birth certificate and they have full parental rights. All persons born on US soil are entitled to US citizenship. So, regardless of where intended parents may be from, their child is entitled to US citizenship. So, most international intended parents will obtain a US passport as the fastest way to get a passport for their child to be able to travel home. But even with that, an expedition, it generally is 4 to 6 weeks of being in the US before most intended parents are able to go home. Okay, some evolving law affecting US surrogacy. So, one of the big changes in the last few years, prior to June 2022, there was a constitutional protection throughout the entire country that a pregnant person had the right to terminate a pregnancy. That constitutional protection was overturned in a case in 2022, the Dobbs decision, and overturned Roe versus Wade. And now we see that there's no federal protection, but every state determines what the law will be in terms of the ability to terminate or continue a pregnancy. So, for example, Texas passed the heartbeat bill, which says that a pregnant person, actually says it's not about her, it's about everyone else. So, no one is permitted to assist a pregnant person in terminating a pregnancy after there's a heartbeat, or essentially around 6 weeks. And that those who assist, and some argue even the Uber driver who drives her to a clinic, could be found liable for damages for assisting and have to be found to have criminal conduct. Colorado is the opposite. Colorado has passed laws to continue to protect a pregnant person's ability to make healthcare decisions, including the ability to terminate or continue a pregnancy, and has passed laws to protect those that assist pregnant persons with making fertility choices. The big concern after the fall of Roe versus Wade is that we've seen many of those who advocated for this change to limit the ability to terminate a pregnancy or to completely eliminate it. Some have directly said IVF is next, that embryos are persons, IVF is not okay. And we do see an example of this in Louisiana law. So in one state of the United States, a law was passed that says that embryos are juridical persons. They cannot be discarded within the state. That would be murder of these juridical persons in theory. So anyone who goes through IVF in Louisiana would need to ship their embryos out of state if they are not using them for conception purposes. The law also says the embryos can sue and be sued. And we did see one example with the famous actress, Sofia Vergara, being sued by her embryos, but in that case, her embryos were not in Louisiana. She did not live in Louisiana, so the case was dismissed for lack of jurisdiction. Another trend that can affect surrogacy is we do see a movement of donor-conceived persons working to change the law. And that has happened in Colorado, not effective yet, but as of January 1st, 2025, there is a set of regulations involving donor gametes where a donor can no longer be indefinitely anonymous. A donor has to agree that their identity can be revealed to any child conceived from their gametes when the child turns 18. The law also limits the number of families that can receive gametes from a single donor. Okay, that was a lot. And then there's more teddy pictures. So thank you for listening.
Thank you so much, Ellen. That was terrific. And being based here in the US, a lot of that rang true. Very good information. I'll look forward to the recording, which will be available on the website later. There's a lot of details there, and your puppy is adorable, by the way. So I think we're now in the Q&A session part of the I3 webinar. So I'm going to ask two questions. First of all, people really want to know where to find your podcast.
Well, thank you. iTunes, Spotify, most places that you can find a podcast, you can search for I Want to Put a Baby in You. You can also go to iwanttoputababyinyou.com, and I think there you can click on to iCloud to listen. But thank you.
Okay, I'm going to definitely do that. And while I have you, and then I think we'll open it up for, James and Keshav and Mara as well, if we can have her ask questions. The question from one of the audience members is, can surrogates meaningfully provide informed consent, given financial desperation? This seems to raise questions of voluntary consent. What is your comment on that?
Yeah, thanks for that question. I would say there's a couple things. One, a surrogate is required to have gone through pregnancy before, so she must have a child. So she must know what it's like to be pregnant. The second element is that she can't be on public assistance for the most part. So while some states can put this into their law, pretty much any agency or clinic will not accept a surrogate that's on public assistance. So they require her to be financially stable to show that she's a good candidate. I've seen exceptions to this rule, but most good agencies, most clinics are not going to pair intended parents with someone who's not financially stable. Part of the reason, of course, is to avoid coercion, to make sure that there's informed consent, and also to just make sure that your child is being in a place that's safe and stable, and that she can get to appointments and do all the normal things to make sure that your child's in a healthy environment.
Thank you. That's a great answer. That makes a lot of sense. Okay.
Yeah, let's take a question from Pedro if he's around. I think we have a question from Betsy, and basically she's asking that what are the living conditions of gestational carriers in countries other than the US? She's wondering if being a paid gestational carrier would be an inductment to put one's life in danger or one's health in danger. Thoughts. If Pedro is not here, maybe Mara can also take up this question. Mara, you have to unmute. Mara, you have to unmute yourself.
She's moving to headphones or something, I think.
Well, perhaps, Keshav, I could come in,
Yeah,
because Betsy asked a related question about the status of surrogates who decide not to finish their pregnancy. And then there was another related question about the implications of Roe versus Wade, which Ellen touched on. And I can only really comment from the UK perspective, but I do think it's a really important issue for wider international discussion, and obviously important in the US. In the UK, the problem doesn't really arise because, as I touched on in my introduction, surrogacy arrangements in the UK and some other jurisdictions are not legally enforceable. So it's not possible to require a surrogate to either adopt a particular lifestyle, diet, or to indeed pursue a pregnancy through to delivery. And there are proposals to change the way in which we regulate surrogacy in the UK. And that will touch on the status of surrogacy agreements between commissioning couples and surrogates. But it certainly won't impact on their reproductive autonomy and their willingness and consent to continue with a pregnancy in circumstances where they may be at risk or they just decide they don't want to continue. And I certainly don't see that ever changing in the UK or indeed being feasible in the UK. But I would be interested whether tonight or another time to talk to Ellen more about the situation in the US, because it is incredibly complicated and concerning.
Yes, Ellen, be great if you could comment as well.
Sure. So I will note another element of Colorado law, particularly, is that a gestational surrogate or any surrogate must have the ability to make all health and welfare decisions for herself and the pregnancy. So she is fully entitled to make all decisions concerning whether she terminates a pregnancy or continues a pregnancy. So we cannot call it a breach of contract if she does not um, to act consistent with the intended parent's wishes. But there are some elements that you could agree ahead of time that compensation would cease if you were to terminate a pregnancy, of course.
Yeah.
Would you say that the Colorado surrogacy bill is the current gold standard in the US? Is that something that not only the US should, I mean, I'm sure you were absolutely key in having it passed. Congratulations. But, you know, there's other 49 states, there's international. Should they be looking at that as a model?
I mean, I will say when Colorado passed its law, we certainly pulled from model acts that many smart attorneys had been working on for many, many years. So there certainly was the goal to go for the gold standard. So yes, but I can certainly see variations in places where it might make sense to do things differently in other states or other countries.
I mean, let's talk about like insurance for a bit. I think there are a few questions about insurance for Ellen and also for our other speakers. Um, Ellen, what's the status of health insurance for surrogates in the US? And again, everyone else can also pitch in about the status of health insurance in their respective regions.
Yeah, great question. I'm gonna go ahead and shout out to my sister, Jennifer White, who co-hosts my podcast with me and loves insurance issues. They can get so complicated and so in the weeds. They are not my favorite, but she loves it. And honestly, that she listens to like these insurance experts to talk insurance and surrogacy every week with new updates because it is that complicated. Where there are different parts where it's possible that the surrogate has no insurance for herself, or maybe 50% of the time she has her own insurance that's surrogacy friendly. So you always have to do this analysis of her insurance to figure out whether it will provide coverage and pay for expenses related to a surrogacy. So we always recommend you have a professional review of her insurance policy completed to understand those risks. Because if you get it wrong, then you could be on the hook personally for all medical expenses. And if something goes wrong, that could quickly be a very, very high number. And then I think I mentioned the liens, that some insurance is even trickier, where it'll say, yes, we provide coverage, but if she's compensated, we're going to take some of that money, that we put a lien against her compensation. So it's an incredibly complex question and area where I highly, highly recommend you talk to insurance specialists or my sister, Jennifer White.
James, you want to pitch in on that question?
No, I mean it's a slightly different
Yeah.
it's a different issue in the UK because much of the healthcare that's provided is free at the point of delivery, so we don't have the same private system. But I can completely understand why in the US it's really important to get good advice on that and think about it well in advance and address it in whatever agreement you're putting together.
Yeah.
I don't think Pedro is here anymore. Yeah, I think unfortunately he had to go off and, you know, deliver a baby, I believe. So this is a general question maybe for for James and Ellen. And Mara, what if you can get your system to let you speak? You can't, oh poor thing. This question is very interesting. What psychological screening and counseling supports are made available for surrogate mothers? And this focuses on the surrogate's emotional health and adjustment. This is a question from the audience. Either of you.
Ellen, do you want
James,
to
you
go
want me to
first?
start?
Sure.
Sure. Yeah, great question, because most professionals in the area consider mental health an incredibly important area of surrogacy and support for the gestational surrogate as well as the intended parents. So, always giving the Colorado example. So, I will say that there is an element of the law in Colorado that requires that a gestational surrogate, prior to entering into a surrogacy contract, must have a mental health consult at a minimum. Most surrogacy agreements include psychological support. So, intended parents paying for her to have mental health counseling, other support groups. Some agencies offer their own surrogacy support groups, but most agencies and clinics take it very seriously, where they think mental health support is key to making sure it's a healthy surrogacy and journey.
That's great. Thank you, James.
Yeah, well, it's similar in the UK. I suppose the main difference is that we really tightly regulate assisted reproduction in the UK. And so in addition to what is good practice, it's actually a legal requirement to offer counselling to patients and anyone going through IVF or a form of licensed treatment. And most clinics will go a step further than that and make it a requirement that people having surrogacy or becoming surrogates are given counselling, not just that they're offered the opportunity. And we also regulate the consent process. So there are strict legal requirements about the nature and the level and extent of information that people must be given, and a huge variety of different forms that people have to complete in order to proceed with treatment. And it's a very prescriptive, regulated regime in the UK, which it doesn't mean that mistakes don't happen, and it doesn't mean that people don't sometimes fall between two stools, but by and large, it ensures that people are well looked after.
It's great that both systems, which are so different, have this available and actually requirement beyond available. I think that's critical. Thank you so much.
Yeah, even in India now, with the new law that's come in, it is a legal requirement for a surrogate to basically consult with a medical practitioner to be deemed fit physically and mentally to undergo surrogacy. So, I mean, yes, I mean these are important aspects that are being touched by almost every regulation out there.
I should have added, it extends to, if a surrogate is married, it extends to her partner as well.
Yeah, that's actually really interesting, and it's really important as well, because we really don't know how that relationship would get altered if the woman is undergoing surrogacy with someone else. Especially in India, this was one of the complications that we were dealing with, and I mean, when commercial surrogacy was like allowed, a lot of women were actually becoming household earners, that they were earning the most for the family through surrogacy, and that was changing the dynamic of the relationship a bit. So very very interesting point by you, James, here. I mean, I have a question for the both of you, and let me just find it. It was basically on attachment of the surrogate with the child. Now, how is that dealt with as far as all of your contracts are concerned? Now, the woman is bearing a child for 9 months. There is a certain amount of attachment that like would come through pregnancy itself. Now, how do you deal with those challenges? Ellen?
Sure. I will say I'm the lawyer, right? Not the mental health professional. But part of it goes back to the answer about mental health professionals giving support and counseling. But I will say there is really a mindset in the United States where, surrogates are often make jokes or refer to themselves as kind of an intense babysitter or teacher. That, a babysitter or a teacher might very much become attached to a child and love that child and care for the child, but at the end of the day, they don't kidnap the child, right? They understand from the very beginning that this is not their child, and of course they want to see this child flourish with its parents.
Absolutely.
Yeah, I mean, I guess it's another reason to to think really carefully about the agreement that you enter into before you go down this route, because it's something that you could try to address in that. In my experience, and as I mentioned at the outset, I advise clinics, not patients. But in my experience of the outcome of treatment, by and large, the relationship is really good, really positive, loving, constructive, and they remain very close and friendly. There have been cases which have gone to court which have been very different to that. And one of the cases that I was involved in a number of years ago was extremely difficult and upsetting for everyone involved, and posed a risk of harm to the child at the heart of this dispute. So if it can be addressed in an agreement, then so much the better. But obviously nobody can necessarily predict how they'll feel a year or two or more down the line. But it's, again, something that's really important to consider.
Yeah. And Ellen, you did talk about like certain states having the provisions of withdrawing consent as far as the surrogates are concerned. Like they can withdraw consent, but like is there a time period?
Well, I will know in that context what I was speaking about was specifically only genetic or traditional surrogacy, where she's genetically related to the child she's carrying, which we see is very, very rare in the United States. So I would guess 95 to 99% or more of surrogacy here is gestational surrogacy, where she's not genetically related. And there is no law in the United States, to my knowledge, that would permit a gestational surrogate to change her mind and not release the child to the intended parents.
Hey, I see Dr. Simopoulou is back with us, but unfortunately she can't still unmute. I was going to give her the last word. Oh well. Well, I think we're very close to the end. If anybody has any other comments, but I think Keshav, I'll hand it over to you.
Yeah, I really like this comment from Emily, and she's actually shared a resource for all of us, which is surrogacy360.org. I personally haven't looked into the website yet, but based on her understanding, I mean, it does keep an update of all the things that are happening throughout the various countries with regards to surrogacy. So maybe we can go out and check that. Now, I hope all of you enjoyed this webinar. I think it was very informative. We would like to thank all of you who actively took part in hosting, in preparing for this webinar, and also all the speakers here who've shared their vast knowledge with all of us. My co-hosts, Dr. Sangita Jindal, Mara, and James, and also the presenters, Dr. Pedro, Dr. Sanjay, Shukla, and Ellen. Thank you so much from the bottom of our hearts.
And thank you very much, Keshav. Can we also thank the organisers and the staff at I3, the International IVF Initiative. Thanks to the organising committee, that's Jacques Cohen, Peter Nagy, Marianne Sevites, Tom Elliott, Fran Farley, Giles Palmer, and Violetta Sura.
Thank you all so much. And our next session is on October 24th, which will be after the ASRM Congress, which is, I think, the 16th through the 18th. So October 24th will be all about disaster preparation and business continuation in a crisis. They have titled it, but they came up with some very creative titles in the meantime, some draft titles. Let me share them with you. Storm Warning, Recognizing and Reacting to Risk in Embryology, Predicting the Unpredictable, Risk Analysis for Embryology Labs and Disasters, and last but not least, Quakes to Quarantines. So tune in on October 24th for the next I3 webinar. This has been a pleasure. Thank you, everybody. Hope to see you at ASRM.
Bye.
Bye.